All right. Okay, so let's see. Yeah, it's been 5 minutes already. So let me let the judge know what's going on and see what he's got to say.
Okay.
Do we have any prior fail to appears in this case that you know of?
Nope.
Okay, because judge will ask that, I think. All right. Let's see. We're ready to go when you are, Judge. Okay, he'll be right out, Mr. Seeger.
Okay.
All right, this is file 204553SM, People versus Jonathan Larson. And Mr. Seeger is here for Mr. Larson, Ms. Wilson for the people. And this is the date for sentencing on the defendant's conviction of domestic violence. Mr. Seeger, let's see, it's about 9:07 now, and your client isn't here for his 9 o'clock sentencing. What have your contacts with him been?
Your Honor, at one point in time, he was contacting me like somewhat regularly. In any event, I had sent him a text message, I believe, last week, and I didn't hear from him. I sent him another one this morning. I did not hear from him. So I'm not sure why he's not here, but he was previously contacting me.
All right. You're not aware of any change of address or something like that, then?
I'm not. If it changed, he didn't disclose it to me, Your Honor.
Okay. Well, at this point, since he's not getting back to his attorney, it seems to me the right thing to do is issue a bench warrant. And we'll reset this when we catch up to him.
Very good, Your Honor. Thank you.
Okay. Thank you.
The courts had no contact with him and some issues as well, actually, back in June 3rd, just so you know. Was it no bond, Judge?
Yeah, we'll cancel bond at this time, and we can reset that if
yeah, he's picked up. Okay.
Picked up. Let's see. Okay. Well, thank you, Mr. Seeger. If he does show up, we'll shoot you an email, but I think we're going to either way postpone this. If he shows up, I guess I'll recall the bench warrant.
That's fine, Your Honor. I'll be back at 10 o'clock either which way.
Okay, great. Thank you.
Yeah.
All right. And I see Ms. Miles is here, and Ms. Miles, you're early, which is good. But we're not going to get started with your case until your attorney is here. So anyhow, you're welcome to hang on the line here, and we'll get started at 9:45. Okay. Thank you.
Your Honor, since you postponed Mr. Larson's hearing, do you no longer need me and would like me just to contact the victim's advocate for a new date?
Oh, Oh, are you, okay, I have the victim listed as Jennifer Zietz, but are you Jennifer Zietz Passberg? Is that how it?
Yes, it is.
Okay, I'm sorry. I didn't mean to ignore you there.
That's okay.
Yeah, what I would do is, I don't know, maybe Miss Wilson wants to talk. Would you like to talk to her in a breakout room about what's going on?
Yeah, I can talk to her in a breakout room.
Okay.
Thank you, Your Honor.
So Miss Wilson is from the prosecutor's office. She'll answer any questions you have, okay?
Okay.
We'll be in recess until the Shyla Bozak matter's ready.
I have a question for you.
Here, come on, dude. Go.
Hi, Mr. Johnson, are you here? Ms. Bozak, are you here?
Yes, ma'am.
Have you spoken with Mr. Johnson?
No.
He's still your lawyer though, right?
Yes.
We'll give him a few minutes here and then I'll send him an email.
Okay.
Oh, there he is. Hi, Mr. Johnson.
Good morning.
Hi, would you like a breakout room with your client or are you set to go?
Breakout room would be appreciated. Thank you.
Okay, you're welcome. Ms. Bozak, I'm going to put you in a breakout room with your attorney, okay?
Okay, thank you.
You're welcome. Ready, Mr. Johnson?
Yes, we are. Thank you.
Okay. We're ready to go when you are, Judge. He'll be with us in a moment.
All right, good morning. We'll get started with People versus Shyla Bosak. That's file 204573SM. And Mr. Johnson is here on behalf of Mr. Bosak, Ms. Wilson for the people. And this is the date for sentencing on the defendant's conviction of domestic violence first. So, Mr. Johnson, if you had an opportunity to review the report with your client.
I'll wait out there.
I have, Your Honor.
And are there any changes or additions you'd like to add?
Your Honor, I'd like to fill in a bit of the information in the personal information section. Specifically, she does have a daughter, one child that does live with her that she is the primary caretaker of.
How old is the child?
She's 2 in August.
Two, you said?
Yes, she'll be 2 in August.
Oh, okay, thank you. All right. Anything, what about education and employment and veteran status, Mr. Johnson? Do you know anything about that?
I know that she is not a veteran and she is a stay-at-home mom.
Okay, what's the last grade that you completed in school or in college?
I'm still online with the SOS school program.
Is that to lead toward a GED maybe?
No, it's still the diploma. They just let you do it until you're 22.
Oh, okay, good. All right. Okay, so any other changes to the report, Mr. Johnson?
No, Your Honor.
All right, Ms. Wilson, any concerns with the report?
No, Your Honor, thank you.
All right, then, Mr. Johnson, what would you like to say on behalf of your client?
Your Honor, at an arraignment, one of the things we always make very clear that we put on the record is what a maximum penalty is. And, you know, I'm always very careful in talking to clients and indicating to them, look, in most cases, that's not going to happen, but you need to be aware of what that maximum penalty is. Unfortunately, in some cases, people don't take that very seriously until that number is staring them dead in the face. And that's where we're at today with Ms. Bosak. Is I don't think she was taking this terribly seriously. And, you know, she had some issues with the PSI. She missed her appointment because she slept through it. And then she called back, but didn't leave a message. And altogether did not show the kind of resolve that somebody in her situation needs to be showing. And what I mean by her situation is she's a very young woman. And to take a look at her record, and granted, a lot of these are relatively minor misdemeanors, but to already have 3 MIPs, a possession of marijuana, and now 2 domestic violence firsts on somebody's record when they're her age shows that there's a real issue, and that issue needs to be addressed. Now, I know that it's my hope, it's the court's hope that people are able to address these issues on their own. They're able to recognize and self-reflect and make these changes. Ms. Bosak has shown that she is not capable of making those changes on her own. And for that reason, Your Honor, I am requesting that the court give her at least one shot at probation. I recognize she's been unsuccessful in the past, but I hope at some point, and perhaps this is that straw breaking the camel's back moment, she realizes that this is not the person that she wants to be. She doesn't want to be in and out of court. She wants to be a mom to her 2-year-old daughter. She doesn't want to miss 93 days of her daughter, which right now means she misses that second birthday, if that's what the court is to order. So it's something to hang over her head that I think is very, very serious, and should be something that causes her to take a look at herself and make some changes, because the way things are going is not working. And yes, these are relatively minor misdemeanors, but the next domestic is going to be a year. And from there, it goes to the Department of Corrections, it goes to prison. And if and hopefully not, she were to go to prison, she's going to miss a lot more of her daughter's life than 93 days. So now needs to be a critical point for her. I think it's worth giving it a shot. Ms. Bosak indicates that she does have the finances to be able to pay for testing. I've indicated to her that any hope she has at probation would certainly come with testing and other obligations. It's not going to be easy for her. She does rely on her significant other for transportation and other things like that. But, probation isn't easy. And there's a reason it isn't easy, because it needs to effectuate change. And I think she's recognizing that now is the time to start making some changes. If she wants to be around for her daughter's life, she has to. So, Your Honor, we would be asking that she be given a shot at probation. I think she can be successful, but at the end of the day, it's going to be completely up to her. She's the only one who has to live with herself for the rest of her life. And if she wants to make the changes, now's as good a time as any to make those changes.
All right. Thank you, Mr. Johnson. Ms. Bosak, I would like to hear from you.
I'm kind of scared to do probation because I'm nervous that I will mess up, because I have several times in the past, but I'd rather try and do that than go to jail. And I feel really bad that I did miss my PSI. I was just irresponsible, and I should have taken more awareness and done more to make sure that I didn't miss it.
Okay, thank you. Ms. Wilson, anything for the people?
Yes, Your Honor, the people would request that the court follow the recommendations in the PSI today. Ms. Bosak has shown in the past that she is not willing to adhere to probation recommendations. And even now, she continues to not take these matters seriously. She's missed her PSI. It's pretty clear that she does not take these matters very seriously. And so for those reasons, we would recommend that the court follow the PSI.
All right. Thank you, Ms. Wilson. So this is sentencing on the defendant's conviction of domestic violence first. It was actually reduced from 2 counts of domestic violence. The facts, as indicated in the report, indicate that there was some issue over the defendant, apparently the father of the child, picking that child up, and the defendant admitted that she lost control and began striking the victim in the head. The victim said that the defendant punched him with a closed fist twice in the face, and later punched him a couple times in the head and face area. So apparently there were 2 separate incidents, but near in time. The defendant comes to the court with a prior record that includes MIP second, possession of marijuana and MIP third. And then a domestic violence in 2018. All 4 probations were unsuccessful. In this case, the defendant did not complete a PSI and failed to answer phone calls. The probation officer did make several attempts to contact her, and that didn't happen. So the recommendation is to sentence the defendant to the maximum sentence, which is 93 days in jail. And I guess what I see here when I look at your past convictions for using alcohol and marijuana is, and the fact that you don't participate, you don't get involved, you kind of ignore everything, as you probably sit around doping and drinking, and you're kind of tuned out to life. That's one way you can go through life. The other is to get your diploma and get a job to help support your child. And convictions for excuse me, I can hear somebody speaking and I don't know who that is, but if you could mute yourself if you're not part of the court hearing, I'd appreciate that. That's just an assumption based on your prior record here, but you can fool the court once or maybe twice or 3 times, but 4 times, now it's just me being foolish. So there won't be any probation in this case. The fine is $75. Costs, I don't know why it says 0, but should be $100. 75 crime victims fund, 50 judicial system fee. There's a $250 court-appointed attorney fee, and it'll be 93 days in jail. There is no credit figure given. Apparently you weren't arrested on this date. And so you need to turn yourself in by 4 p.m. this afternoon to the Grand Traverse County Jail.
Okay.
You will remain on probation until that time, and fail to turn yourself in could result in a contempt violation. We're all set for today. Feel free to sign off. All right, moving on to Jasmine Miles. This is file 215011SM. And Mr. Connolly is here on behalf of Ms. Miles. And let's see, Ms. Wilson for the people. And I see we do have a couple of the victims in the case, Whitney Richardson and also Tevin Miles are here. So, and you will be given an opportunity to speak at some point during the hearing, okay? So,
Your Honor, if I may interject real quick, I believe Ms. Wilkenberg was planning on appearing for this case. If you would allow me to go check and see if she's still
absolutely.
planning.
Go ahead.
Okay, thank you.
Okay.
Those were on this case, Judge. I just got them in an email.
It sounds like she's logging on. If you could give us a few seconds. Oh, there she is.
Okay.
Thank you.
All right. So we have Prosecutor Mogenberg here. for the people. And are you in the meeting now, Ms. Mogenberg?
I am, Your Honor, and I apologize. I was just on Zoom with Judge Power, but now I'm getting a message that my camera won't start. So if it's okay, I'll.
Okay,
If that's
that's
all
just fine.
right.
Okay, and we do have Ms. Miles and her attorney, Mr. Connolly, here, as well as, well, you can probably see everybody else on the call, I'm assuming. Oh, I didn't mention Emily Miles, who is also present now. Okay, so Mr. Connolly, have you had an opportunity to review the pre-sentence investigation report and the victim impact statements and other letters that were submitted on the defendant's behalf?
I have, Your Honor. We find the pre-sentence investigation report to be accurate and complete. No additions, changes, or corrections there, Your Honor.
Okay, so what would you like to say then on behalf of Ms. Miles?
Well, Your Honor, first off, obviously, Ms. Miles has no criminal history. 29-year-old young lady, no criminal history. Sounds like she has, from the report, a myriad number of health issues that she's dealing with. I think what happened on the date in question was that there was a combination of some overwhelming issues with her mental health and the stressful situation, and Ms. Miles acted out in an entirely inappropriate manner. And she'll acknowledge that her behavior was completely inappropriate, Your Honor. What I have noted in talking with Ms. Miles about the case and about her plans for the future is she does have a willingness and a desire to participate in counseling, to learn what it is that triggered that anger or what triggers her anger, and to learn some coping skills going forward so that she doesn't act out in a violent, threatening, or harassing manner in the future towards anyone, family, friends, period, Your Honor. So I think it's a good sign, Your Honor, that Ms. Miles has been willing from day one to get some advice on what kind of counseling is appropriate, to get some advice on how to make sure this never happens again. Certainly not all of my clients take that approach, Your Honor, but I think this is a woman who certainly has the right focus in mind, and I think she'll do well on probation. And again, Your Honor, it's always sad when you see situations like this where there's siblings or family members where clearly there's been a breakdown in the family relationship, and it always makes it harder, Your Honor, when you see a situation like this. But again, I think Ms. Miles has the right attitude and the right focus.
All right, thank you, Mr. Connolly. Ms. Miles, I would like to hear from you. Is there anything you would like to say?
Sir, I am very sorry for my actions, and I've learned from my mistakes. I understand that what I did was wrong, and I've learned, and I'm not going to ever make that mistake again. And I'd like to apologize to my siblings for my actions. I am truly and deeply sorry for what I have done.
All right, thank you. So, Ms. Mogenberg, anything for the people?
Your Honor, both Tevin Miles and Whitney Richardson are present. I'm not sure about Mr. Miles, but I know that Ms. Richardson wished to address the court.
All right, and so Ms. Richardson, this is your opportunity to provide any additional information to the court that you would like me to know. I want you to know I did review your victim impact statement and very carefully, and I also reviewed letters from, I believe, your husband and your daughter, and speaking about your continued problems with memory and from the injuries that you suffered. And let's see. So anyhow, with that, go ahead. Let me know anything you want me to know.
Your Honor, if I may, can I read my impact letter, even though you have read it already?
Yes, go ahead.
Right, thank you, Your Honor.
It's not just about me, it's your opportunity to address Ms. Miles as well.
Correct, yes. Dear Judge Cooney and Jasmine. Hi, my name is Whitney Richardson, sister to the other two victims, M. Miles, Kevin Miles, and the assailant, Jasmine Marie Miles. March 21, 2021 is a traumatic day that I will relive over and over again. This is the day my sister, Jasmine Miles, violently assaulted me in my father's condo. The physical and mental trauma she inflicted will affect me and my family for the rest of our lives. I cannot begin to describe the terror I felt realizing that Jasmine had her hand pinning the back of my neck and the entire weight of her body on my shoulders and back. I was helpless and unable to fight back. My older sister, M. Miles, intervened because she was afraid that I would die from Jasmine's punches to my head and neck and suffocate in the pillows due to being forcefully restrained. Growing up in the same household as Jasmine, we have lived through and experienced her constant rage and violence. I do not know what the outcome would have been if M and Tevin did not intervene. I am a strong, loving wife and a mother of 4. I own a house cleaning business and am independent. However, this assault has changed every part of who I am. It has become difficult to be the wife and mother my family needs, knows, and deserves. I have not been cleared to return to work by my primary physician, which has caused a lot of frustration and financial stress on me and my family. I am constantly going to medical appointments. I see my primary physician regularly, physical therapists twice a week, and therapists to work through the trauma of her assault. I have been referred to a neurologist because of the damage inflicted by Jasmine. Recently, I had MRI done on my brain and cervical spine. They discovered my C3 and C4 has some injuries due to the impact of her assault. I have bulging discs that will require further testing and treatment. I have also been referred to the Physical Medicine Associates of Northern Michigan to assist with my pain. I have been diagnosed with a concussion, traumatic brain injury, head hematoma, neck contusion, neck sprain, and post-traumatic syndrome disorder. I have been told by my optometrist that my vision has changed, most likely due to the impacts to the back of my head inflicted by Jasmine. I struggle daily with anxiety, dizziness, short-term memory loss, speech delays, and balance issues. I have constant headaches and severe pain in my back, shoulders, and neck. I also live in fear that I may see Jasmine's car in my driveway. I panic when I see a vehicle that looks like her SUV or someone who resembles her physical appearance. Moreover, I fear I may run into her at the store, a family event, or at my father's house. I am the daughter of my father, calls for help, and I am also his primary caretaker when he needs assistance. I spend a lot of time at his house and keeping him company. Currently, there is a no contact order in place against Jasmine at my father's home. This is also where my brother Tevin Miles lived. I am concerned since his case was deferred in Jasmine's plea deal from May 28 that Tevin and I will not be safe in my father's home once the no contact is lifted. I may not be able to return to my business due to long-term physical effects from Jasmine's assault. This is becoming a reality to how physical and strenuous cleaning houses will be to my body. This has caused me to sink into deep depression, and sometimes I feel hopeless. I have frequent recurring nightmares about my attack, which creates many sleepless nights. The strong, independent, helpful, and positive mother has been overshadowed by trying to work through the trauma of her assault and getting my body back to being healthy, which may never happen. I will live with Jasmine's physical and mental assault for the rest of my life, and I am only 44 years old. This is now my life, my reality, my new normal. Your Honor, I would ask the court to look at the severity of Jasmine's crime beyond her plea deal. Upon sentencing, I humbly ask that you consider the lifelong impact her assault has had and will continue to have on the quality of my life and my family. Jasmine's violent assault has cost me emotionally, mentally, physically, and financially. Respectfully, Whitney Richardson. Thank you, Your Honor.
All right, thank you, Ms. Richardson. And Mr. Miles, is there anything that you would like to say today?
Yes, I also do have a what's it called?
A statement.
A statement.
Okay, go ahead.
Thank you, Your Honor. Dear Judge Cooney, before I was assaulted by Miss Miles, I didn't think about anyone hitting me. Even though we didn't always get along, Miss Miles is still my sister, and we went to places together, like family outings or lunch with our dad, Bill Miles. Sometimes she would come to where I live, and we would say hi or ask other persons how they are doing. Now I don't want anything to do with Miss Miles because of the no contact order, which I want to stay in my house as long as possible. She can't come to my house, but that also means she has to make other arrangements if she wants to see our dad. I know this has been hard on my dad. He doesn't like it when his kids are not getting along. This has been really hard on our sister, Whitney Richardson, who was the other person Miss Miles assaulted that day. She hasn't been able to work and is still receiving medical help because of Miss Miles punching her in the head nonstop that day. Not having her income is probably hard on her family. I've also been afraid that Miss Miles is going to come to my house or at work and places where I shop to cause problems. I know she can't because of the no contact order, but I'm afraid she might anyway. I don't have any other places to go to make it easier for Miss Miles to visit my dad because my mom moved to the UP. When my stepmom moved up to the UPs to start her new job, I was afraid that Miss Miles might try to take advantage of the situation and show up at the house. Miss Miles didn't show up, but I was pretty nervous and very anxious during that time. This also has affected my extended family, my aunts, uncles, cousins, nieces, and nephews, who would normally see us at our family get-together. Because of the no contact order, Miss Miles wouldn't be able to be with them if I was there, and so they won't be able to see her. Some of them live way outside of Traverse City, and I don't want to miss seeing them because I don't get to see them very often. While I feel bad for Miss Miles, she put herself in this situation by assaulting Mrs. Richardson and me. When Miss Miles assaulted me, she hit me very hard in the face, on my head, on my back, and there was blood coming out of my nose, and it was everywhere. The ambulance was called. For a while, everyone thought my nose might be broken. It hasn't, but it did hurt, and I was in pain for several days. I also dropped to my knees hard and got back up to do a move that I learned from my Taekwondo classes so I can get out of my attacker. I did go to see my doctor after the pain didn't go away for several days. Unfortunately, he said I just had bruises and little scabs and needed to take it easy and take ibuprofen for the pain. As I mentioned before, I've been afraid of that Miss Miles would show up where I'm at, home, work, or any stores, and that she might do to Mrs. Richardson, if she was there to see us out somewhere alone. I did not have any costs for the medical service I received. Also, on March 21st, on Sunday, I included a letter to the victims advocate along with the form I was asked to fill out. In that letter, I wrote sentence, I have autism spectrum disorder. I asked that all communications about this case also been sent to my stepmother, Rebecca Rogan. She can help me to understand what it all means. I gave her the email address and phone number. Mrs. Rogan has never been contacted. This caused me more and more stress as would have helped me. Because of the seriousness of the injuries, particularly to Mrs. Richardson and the numbers of people Miss Miles assaulted, Mrs. Richardson and me, I don't think Miss Miles should have been given any kind of plea bargain. Even though this is the first time she has been arrested for something like this, I don't think this prosecutor's office took this case or the damage that Miss Miles did very seriously. Mrs. Richardson is still seeing doctors and having tests done because of this assault. I've been afraid of seeing Miss Miles because of how angry she got that day over nothing and her overreaction. Before there was a no contact order, Miss Miles sent some text message to me, threatening messages to me, threatening and trying to get me in trouble with law enforcement and the court. She said she was going to sue me because she shoved her hand into the door when I was closing it. Her threat just made my anxiety worse. I think the only way Miss Miles is going to believe she did anything wrong is if she goes to jail for a while and then has to be on probation for a long time. I would like to see her go to jail for a long time, but I know that isn't going to happen. I just know she isn't going to think she did anything wrong or learn anything because of this plea agreement. It also made me angry that the prosecutor's office didn't contact me or Mrs. Richardson to talk to us about the plea, even though we both asked to be contacted about any possibility pleas. If Mrs. Richardson had not kept contacting the prosecutor's office, I don't think they would have any contact with her. I don't know if they even talked to Mrs. Richardson about how badly she was hurt by Miss Miles' assault. One other reason I don't feel like the prosecutor's office or the court has taken this case more seriously is because when Miss Miles was first let out on her bond, the only person who was covered by the no contact order was Mrs. Richardson. It wasn't until my stepmom, Rebecca Rogan, got involved and contacted the prosecutor's office about the oversight was a second hearing held and the no contact order was extended to cover me as well. How was this missed? The police had everyone's information. Mrs. Richardson, my other sister, Miles, who is still a witness, and I wrote out your statement, which I think were attached to the police report. It just doesn't seem like it was taken seriously. I just hope the court will realize this was much more serious than that what it has been led to. Was led to believe will try to do the right thing by the victims and really hold Miss Miles accountable for this attack. I also want the no contact order to stay in place as long as Miss Miles is under the control of the court. Thank you.
All right. Thank you, Mr. Miles. I appreciate your comments today. Would Emily Miles care to address the court as well?
Yes, Your Honor.
Okay, go ahead.
Dear Judge Cooney, my name is Emily Hengy Miles. I'm the older sister to Whitney Richardson, Tevin Miles, and Jasmine Miles. I was at our dad's condo the day of the assault on Whitney and Tevin. I would like to share what I have witnessed and experienced on March 21st, 2021. Whitney and I spent the day before the assault cleaning my dad's condo on March 20th from 1 o'clock till 5:30 p.m. We returned on March 21st to continue cleaning at 1 p.m. Jasmine was informed we would be there that weekend to clean. I was about to start a load of laundry when Jasmine forcefully swung her bedroom door open and began yelling at us for being too loud. I expressed to Jasmine that we need to help Dad clean. Jasmine raised her voice and told us that she did not care and that she's filming. I explained it to Jasmine that we have been cleaning since yesterday, March 20th, and it's almost 3:30 p.m. and what time she would be finished so that we could start the laundry, the washing machine. Jasmine did not answer and raised her voice at Whitney and said that she was filming in her room and slammed the door again, closed. As Whitney finished cleaning the bathroom off the hallway, Jasmine swung her bedroom door open again and yelled that she was filming. I was in the hallway putting laundry and towels in the washer machine. I calmly explained to Jasmine again that we really need to start the washing machine for Dad. I asked for her second time, when she would be finished filming. This is when Jasmine became physical. She began yelling, "I don't care," and pushed me hard. Whitney was standing behind me and I landed on her. Jasmine slammed her bedroom door. I was startled by her behavior and opened her bedroom door. I did not step in her bedroom. None of us did. And open her bedroom door. I did not step inside her bedroom to I explained it to Jasmine that I flew in from Texas to help Dad clean and prepare his condo to be placed on the market, that there was no need for her to push me. Therefore, she grabbed the door, slammed it again. This was at 3:44 p.m. Approximately 5 minutes later, Jasmine opened her bedroom door again and approached Whitney. I noticed that she had changed her clothes as well. She began screaming at Whitney and I to get out of her apartment. She turned to Whitney and said, "Get out." Sternly, Whitney told Jasmine that we were at the condo to help Dad. This is where Jasmine claims Whitney spit on her. That did not happen, Your Honor. Jasmine is lying. Jasmine then yelled that she doesn't care, and Whitney responded, "We do, we care." Jasmine moved aggressively towards Whitney and punched her in the face, knocking Whitney's glasses off to the floor. Whitney was in shock and responded that she can't believe Jasmine punched her. Whitney then called Jasmine a crazy, bitch. Our dad, who was sitting in the living room, yelled, "Enough, Jasmine." This is when Jasmine lunged forward at full speed and forced Whitney to Dad's bedroom. Jasmine is at least twice the size and weight of Whitney. Jasmine forced Whitney face down on Dad's bed and pressed her head between one of the pillows while using her body to pin Whitney to the mattress. Jasmine began punching Whitney's head, neck, and back. She would not stop. I begged Jasmine to stop, but she did not hear me because she was screaming at Whitney while continuing to punch Whitney with her right fist. I could not see Whitney's face, but did hear her scream at Jasmine to get off of her. over and over again. I was really scared. I grabbed Jasmine's right arm, the arm that she was using to punch Whitney. I yanked her arm hard, but I was having difficulty because I'm only 107 pounds. I was still unable to see Whitney's face. And once again, I tried to pull Jasmine's right arm to stop her from punching Whitney. Before I knew it, Jasmine swung her right arm at my left ear. This was just enough time for Whitney to escape from under Jasmine's and run out of the room to call 911. Jasmine ran after Whitney. I was able to catch up with Jasmine and wrap my arms around Jasmine. I told Jasmine, I love you. Please stop. That you can't behave like this. Jasmine's response was to scream that we owe her $400 because that's how much she makes filming on the weekends. Jasmine then rushed out to the living room where Dad was sitting. My brother Tevin Miles was in the living room helping my dad pack. Jasmine then called Tevin stupid and retarded. Tevin got upset, grabbed his jacket, and started running out the condo towards Whitney. Jasmine immediately rushed out after Tevin. I followed Jasmine and yelled at her, please leave Tevin alone. Jasmine continued to chase after Tevin and Whitney. When Tevin saw Jasmine running after him, he got scared and slammed the door to the building complex building behind him, catching Jasmine's left arm between the door. Jasmine screamed, you closed the door on me, stupid. The rage in Jasmine's was scary, however, not uncommon, and she focused her anger towards Tevin. Jasmine began attacking Tevin and punched him repeatedly in the face. Tevin never retaliated and took every punch from Jasmine. During Tevin's assault, Whitney was outside on the phone with 911. At 4:06 p.m., the first officer arrived. When Jasmine saw the officer, she rushed back inside the building and sat in the corner of the front entrance and said that she was going to call 911 as well. 2 more officers arrived. At approximately 4:30 p.m., Jasmine was arrested. The day Jasmine attacked Whitney and Tevin had a profound impact on me. The trauma of witnessing Jasmine attack is painful and continues to stir up memories and emotions. Although the attack happened on March 21st, almost 3 months ago, I'm still processing what I witnessed and feel a great deal of pain, anxiety, and stress. I live in Austin, Texas, which is far from Traverse City. My greatest fear is that Jasmine will attack Whitney and Tevin again. Next time, I may not be there to protect my sister Whitney and my brother Tevin. Your Honor, I'd like to say that the outcome of the assault on March 21st to Tevin and Whitney could have been more tragic. If I hadn't been there, Whitney would not have the opportunity to escape and to call 911. Tevin, Whitney, and I offered to help Dad because the condition of our dad's condo presented safety and health hazard to him. We volunteered because Jasmine, who was living there, never cleaned up after herself. In fact, she never offered to help out, but to cause more problem for our father and for those who tried to help my dad. Thank you.
All right, thank you, Ms. Miles. Ms. Mogenberg, is there anything you'd like to say on behalf of the people?
Thank you, Your Honor. Just that obviously this is a tragic case all around. The defendant in this case has some obvious mental health issues that were detailed in the pre-sentence report and has acted out against her siblings, kind of tearing apart the entire family. Hoping that with probation, she can get help for some of these issues and we can prevent this from happening again. I would ask the court to, with respect to the pre-sentence report, add Tevin Miles to the no contact. Right now, I believe it just says Whitney, to ensure that she does go to the AWARE program. And if at all possible, to have her cooperate with whether it's community mental health or a private care provider, and to take her medications as prescribed as part of her probation, because I think that may be the most significant change for her and then for her family. Thank you.
All right. I want to confirm, because I saw it in some of the letters, Ms. Miles, Jasmine Miles, are you currently a patient with CMH?
No, sir.
Have you been in the past? I saw that in a letter from your aunt, Miss Elliott.
Yes, in the past I was, but I'm not anymore. I see a different doctor, sir.
Is that the one at Pine Rest, perhaps?
No, sir. My doctor who prescribes my medicine is at Partners in Health Clinic, sir.
Okay, and are you receiving some sort of services currently for this incident?
Can you explain what you mean, sir? Because I'm...
Well, some sort of mental health care from a psychologist or a doctor?
Oh, I am, well, no, not right now. I'm waiting so I can do my counseling, sir.
All right, are you talking about the AWARE program, or are you talking about seeing an individual counselor?
I'm going to do both, sir. I was told to wait until there was a program through this, and then on my end, I am looking for a counselor for myself as well, sir.
All right, and you've spoken to your doctor about medication, and are you currently taking some medication to control your behavior?
Yes, sir.
And it's alleged by your Aunt Elliott that you stopped taking medication, and I saw that in a couple of different places where you stopped taking medications, and it's believed that perhaps that is something that led to this. Is that, do you think that might be true?
Your Honor, I have been taking my medication since I have gotten to my new doctor continuously, because I realize that it helps me. So
who's your doctor? What's his or her name?
Crystal Allenheimer, I believe. I don't know how to pronounce her last name. It's really hard. But I have, in the past, I used to stop taking my medication, but I haven't done that in over 3 years.
Have you talked to Dr. Allenheimer about this incident specifically and what happened?
Yes, sir. We upped some of my medication and changed some of my medication.
Because I know that you're saying you're apologetic for this today, and I'm sure you are. It must be painful to have your 3 siblings here, as it is painful for them to be here and make these statements. And I know you're someone who's interested in childcare, and you've done some of that. You have an associate's degree in early childhood education. And, you know, the last thing anyone would want is for these violent behaviors to be acted out on children, let alone your siblings. You understand that, don't you?
Yes, Your Honor.
And that is why it is so very important that you seek the right mental health counseling and take the proper medications and work with your doctor on that to make sure that something like this never happens again. Do you understand that? Okay. There are a number of letters in here that you provided the court that talk about what a loving, caring person that you are. And I don't doubt that. And I'm sure your siblings would probably share some similar thoughts. that when you are treating the significant mental health issues that you have, that you can be a very kind person. And I don't doubt the people that wrote this, mostly from your church and some friends and that sort of thing. But you have to do something to control this, because I don't necessarily disagree with the way that the prosecutors handled this. I can understand Mr. Miles' concern about the plea offer that was made here. But the fact is, this is the defendant's first involvement with the criminal law. There are significant mental health issues going on here, and this is not the sort of thing that, I could just sentence the defendant to the maximum possible, the 93 days in jail, but then she would be out, and we haven't really addressed any of the underlying issues that led to this. I want to make clear that based on the letter provided by Ms. Whitney Richardson and her family, these were serious injuries. She's still having memory loss issues. She has headaches and pain. And this is this happened back in March, and that's still going on. This could have potentially been charged more seriously as a felony offense, given the serious nature of the injuries, given, at one point it appeared you were on the bed and, I don't know, perhaps trying to suffocate your sister or choke her in some way. But again, this is a situation involving someone with some significant mental health issues. Those have not stood in your way most of your life, because you have a family that I believe, despite the comments today, they care a lot about you. A lot of family members who wouldn't be here at all because they just don't care. But I think they do care, and they want to see the right thing happen. You've also managed to earn this associate's degree in early childhood education, and you're a well-liked member of your church family, and you do a lot of volunteer work there. But so anyhow, the primary purpose of this sentence is going to be to try to address the underlying issues, make sure something like this doesn't happen again. But I do want you to understand it would be real easy, based on these facts and the injuries, to simply throw you in jail for the whole 93 days. And I will do that if you do not comply with all of these conditions of the probation. Okay?
Yes, sir.
So the probationary term is going to be for the maximum 2 years. I think that's required because, again, of the serious nature of this incident, and because I think the court needs to monitor the situation for a longer period of time, given what happened. The fine is $100. The costs are $400, not the $800 listed. $75 Crime Victims Fund, $50 judicial system fee, and there's a $250 court-appointed attorney fee. The defendant is not to reside where there are any weapons or firearms present. You're not to be in possession of weapons or firearms. You're not to behave in a violent, threatening, intimidating, or harassing manner toward anyone. You're to be respectful of all court employees and service or care providers. You are to attend the AWARE program, 36 weekly sessions, no unexcused absences. This would be a program that would be beneficial to anyone, whether they've been convicted of a crime or not, but they will teach you some tools to try to manage your anger better. In addition, you are to complete an intake with an approved mental health counselor. Follow all recommendations, provide all information pertaining to this incident to the counselor. And that includes the statements that were provided to the court today. I want your mental health provider to see everything that I have in this case before they jump to some conclusions based on maybe what you're reporting. Okay?
Yes, sir.
I want you to continue to have regular visits with your doctor, Dr. Olenheimer, and follow all of her recommendations regarding any prescriptions that you have. And you need to provide a release to the court with both the mental health counselor and Dr. Olenheimer so that the court can monitor that you're going to those appointments and to speak to them about your medical treatment. There will be discretionary drug and alcohol testing at the request of the court. That is for the purpose of making sure that you are taking your medication according to your physician's directions. You are to have no contact with your sister Whitney Miles Richardson or with your brother Tevin Miles. And I'll ask Emily Miles, would you like a no contact provision with regard to yourself? Even though you live in Austin, Texas, I'm sure you'll be visiting your father and siblings from time to time.
Yes, Your Honor.
Okay, so I'll include Emily Miles as well. And I do find, based on her statement, even though it wasn't charged, that she was assaulted as well. You're not to go within 500 yards of the residence or workplace of any of those persons. I am not going to impose additional jail time, and this is the reason. I want to have as much jail time over your head as I possibly can because I want to see you follow through and complete all of these conditions, and I think you'll be in a much better place when you get there. This is a deferred sentence. The other thing is, I want to speak directly to your siblings about this. For someone who has never been in a jail before, arrested, handcuffed, put through the booking process, thrown in a cell, it is quite an experience and a change of thought. And so if this were someone that had been through the jail system multiple occasions, I might feel the need to impose some more jail time up front, but I'm not going to do that because of the impact that I think even a brief day would have on a normal person. And so, Ms. Miles, you've seen the inside of a jail now. You know what that's like. I'm sure you never want to be back there. I don't want to see you go back there. I think everyone on this call today doesn't ever want to see you get into this kind of situation again. But your family is afraid of you. They're here because they want to see you get help. And that's what the court wants as well. Other than that, you are to notify your probation officer if you have any contact with law enforcement, and you need to contact your probation officer between 1 o'clock and 4 p.m. today, actually the probation office. and the number is listed on the pre-sentence report. So make sure you take care of that detail. They'll answer any questions you have about the conditions of probation and go over those conditions with you in more detail. All right, well, I want to thank all of the family members who were here today for giving me more information about this case and helping the court come to the conclusions it did. Sometimes I like to say there's a rough sort of justice that goes on in these cases. I'm sure the court's sentence today doesn't even come close to helping Miss Richardson with all the issues that she may be facing in the future as a result of this, or some of the anxiety and stress that Aaron Miles or Tevin Miles has suffered as a result of this. But hopefully at some point your family will be able to, because of these probationary terms, get back together. And so that's it for today. Thank you all. Feel free to sign off at this time.
Thank you, Your Honor.
Your Honor.
Thank you, sir.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Okay, that takes us to plea in People versus Roy Kowalski. And I see Mr. Warden is here. Is Mr. Kowalski also present?
Your Honor, he's in the jail.
Oh, okay. Let's see. Did we let the jail know about that? It's Roy Edward Kowalski. And he's here on two different files. So we'll go on to People versus Zarco, Ramon Zarco. Mr. Zarco, are you present?
Yes, sir.
All right, so this is file 215145SM1, and Mr. Zarco is here with his attorney, Mr. Seeger, and this is the date for sentencing. Oh, and Ms. Wilson is here for the prosecutor. This is the date for sentencing on defendant's conviction of domestic violence with a deferral. Let's see, Mr. Seeger, have you had an opportunity to go over the pre-sentence report, and is it accurate and complete?
Your Honor, I did have an opportunity to review a copy of the pre-sentence report with Mr. Zarco. There is one addition, correction, or deletion. There's a statement in the pre-sentence report indicating that he may have acted in self-defense. And further discussion with him, I think that statement may have been somewhat misinterpreted, in as much as he's not disputing that what he did amounted to domestic violence, that at some point in time, maybe, arguably, there could have been perhaps a case of self-defense, but he pled guilty. And if there was a defense, it's waived by virtue of his plea, and he exceeded the scope of any self-defense claim had that been the case. But nonetheless, Your Honor, in speaking with him, he is not claiming self-defense. And so I just wanted to make that correction to the report.
Okay, thank you, Mr. Seeger. And I do think that that's clear from the report itself, because the defendant does say that it was self-defense, but I'll add a line I guess the defendant admits through his attorney, if self-defense,
So you should be ready to go, okay? Okay, thank you.
exceeded lawful self-defense. All right. With that, is there anything else you'd like to say on behalf of your client, Mr. Seeger?
Your Honor, I would just ask the court to grant him the benefit of the deferral. He does not have a long, extensive criminal history. And albeit I do understand, and the court just handled the case between brother and sister. I somewhat factually distinguish what domestic violence means. It doesn't mean that it can't involve a family member per se that's a brother or sister. I just think that it's somewhat distinguishable because I think the intellectual underpinnings are probably more related to that of somebody who is in a dating relationship. And because they're not living together specifically, I think that perhaps the statute is more geared towards that. But be that as it may, Your Honor, it still qualifies as domestic violence under the statute. Mr. Zarko has expressed a great deal of remorse. He wishes that it wouldn't have happened. I think that if he's given an opportunity to be placed on probation, if he has the opportunity to adopt a deferral to the extent that the court grants it, I think that he will benefit from that. His family will benefit from that, and he'll have the opportunity to not have this on his record. So to that end, Your Honor, I would just ask the court to consider granting him the benefit of the deferral.
All right. Thank you, Mr. Seeger. And I would like to hear from you, Mr. Zarko. And I would like to ask, is that you, Ms. Wilson, perhaps on the iPhone, or is that someone else?
That's Dakota Bay. I have a hearing here soon.
Oh, okay. All right. I didn't want to just ignore the victim if she were present. So, okay, go ahead, Mr. Zarko.
I would just like to say that I'm sorry for what I did, and I do love my sister. I have not been back to that residence at all, and I have not been in contact with Captain Wilson. I am willing to do the probation. I don't really like Mr. Seeger was saying I don't have a criminal record of in and out of jail. Nothing like that. The only thing I've really gotten in trouble for was an MIP back in 2017, I believe it was.
Yeah, I see your probation was revoked in that case. How come?
It was just misunderstanding. I wouldn't stop smoking for quite some time, but
Okay. Anything else you want to say?
No, sir.
Okay. Ms. Wilson, is there anything you'd like to say on behalf of the people?
The people just asked that Your Honor follow the recommendation in the pre-sentencing report. Thank you.
All right, thank you. Okay, so this is argument between a sister, Ms. Wilson, and the defendant. And the defendant described shoving his sister down twice because in his words anyway, he said she was going to hit him. Now, he denies ever actually hitting her. However, according to the victim, the defendant pushed her, struck her in the face twice, and there was a mark observed on her lip where she was struck. The defendant admits that if he was at some point defending himself, he exceeded that right to self-defense. And I do agree with the probation officer that the defendant does appear to have minimized his actions by placing the blame on his sister. The defendant says that he believes he does have an anger issue, but that it is controlled. I would note that the defendant does have one prior criminal conviction that was in 2017, and it's concerning the probation was revoked because apparently he wouldn't stop smoking. I assume that means marijuana, and the defendant admits he continues to use marijuana, and so based upon the facts in this case, I do believe that, and the fact that that prior conviction is an MIP, it's not assaultive. It was 4 years ago, and the defendant is still a young man, 21 years old. To his credit, he is working, although I think could probably do better than the part-time jobs that he has. And, you know, it's hard to get by with an 11th grade education, Mr. Zarko. Have you thought about getting a GED or a high school diploma?
Yes, Your Honor. I'm currently doing online schooling for native school.
Oh, you are? Okay. And that's supposed to lead to a diploma?
Yes.
Okay. Well, good. I'm glad to hear that. So what I'm going to do is place the defendant on a probation for 1 year with the right to a deferral. It's been specifically pointed out to me that that was part of the agreement in this case, so I'm not going to review the case automatically at the 6-month mark. There's a fine of $100, costs $400, Crime Victims Fund $75, judicial system fee is $50, and the court-appointed attorney fee is $250. During the term of the probation, the defendant is not to consume or be in possession of alcohol, no illegal drugs, no mind or mood altering substances, no non-prescribed medications. If you have a prescription, provide it to your probation officer within 48 hours. You're not to consume or be in possession of weapons. I'm sorry, mixing that up. You're not to be in possession of weapons or firearms. You're not to live where those are present or where any of those substances I described earlier are present. You're not to enter any bar or casino. I won't extend that to restaurants, and I will make an exception if you do obtain employment that involves possession of alcohol. You're not to behave in a violent, threatening, intimidating, or harassing manner toward anyone, and be respectful of all court employees and care providers. You're to complete the men's program and cooperate in that program with no unexcused absences. And I know you're saying you don't have an anger issue, or you do have an anger issue, but it's controlled. Well, I'll tell you what, this class is designed to give you the tools that are commonly accepted means of trying to make sure you don't act out in an aggressive manner. And anyone would benefit from that. You have to go anyway, so please use the time wisely. Don't just show up and sit in the back row and sleep, okay? That's not cooperating anyway, and they'll report you for that, and you'll have to either start over or there'll be a probation violation, okay? But take it seriously, because you know you said you love your sister, and if you don't want things like this to happen in the future, well, you got to do something about it. There'll be once a month random drug screens, discretionary drug and alcohol testing, a benchmark urine screen tonight, no contact, directly or indirectly with Catherine Wilson, and you're not to go within 500 yards of her workplace or residence. The jail time is 4 days, and credit for time served on that. So because this is a deferred sentence, you will not do any additional jail time unless you violate the conditions of the probation, and you have the ability to get this off your record if you if you comply with these conditions. Let's see, you need to notify your probation officer of any contacts with law enforcement. And then I need you to contact, one more condition. I want to see you complete your GED or diploma. Doesn't matter which, but I would encourage you to get that diploma while you're on this 1-year probation, or at least make progress toward that. You need to contact the probation office sometime between 1 and 4 o'clock today. There's a number on the pre-sentence report for you to call, and they'll explain all these conditions of probation in more detail to you and answer any questions that you have. Is there anything else for you, Mr. Seeger?
No, Your Honor. Your Honor,
yeah.
Is it possible to put Mr. Bayat and I in a breakout room?
It is possible, and I will go ahead and do that right now. Okay, problem is I have 2 iPhones on my participant list, and I don't know which one is you, Mr. Seeger.
If I turn my video on, does that help?
No, it doesn't really help because I have to pick on it from a list that says iPhone.
Here,
And so I'm going to put both of you. I'll tell you what, I'm going to put both of you in there. And whoever is not supposed to be in the meeting room could just leave, okay? So here we go. Or don't accept the invitation to the room at all. Okay, let's see. We have Mr. Kowalski here now from the jail. And Mr. Warden, are you still here? Yep. Mr. Warden? There he is. Okay. Let me know when you're ready to begin, Mr. Warden.
All set, Your Honor. Thank you.
Okay, so we're here on 2 cases involving Roy Edward Kowalski, file 190891FY, which looks like a possession of controlled substance, and file 214943SM, which is a domestic violence case. Both cases are scheduled for a plea today. Is that what your client wishes to do, Mr. Warden? And if so, is there any plea offer that's been made?
Yes, Your Honor. Pursuant to the stipend order for remand, the controlled substance case will be a plea to use of cocaine, a 1-year maximum misdemeanor. And then he will be pleading no contest to domestic violence in 21-4943. The basis for the no contest plea is he was on medications and has no recollection of the incident.
Okay, I see that Mr. Atwood is here. I'm not sure if he was on any part of this case, but Mr. Atwood, is that the plea deal? Apparently it was a stipend order. Okay, thank you. All right, so most importantly, Mr. Kowalski, is that your understanding of the plea agreement? The felony possession of cocaine would be reduced to a misdemeanor, use of cocaine, and you'd also be pleading no contest on the domestic violence case.
Yes, sir.
All right, has anything else been promised to you to get you to plead guilty that has not been stated on the record this morning?
No, sir.
Have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, sir.
Do you understand that by pleading guilty, you will have a conviction for use of cocaine, and that carries a maximum penalty of up to 1 year in jail? You'll also have a conviction for domestic violence, and that carries a maximum penalty of up to 93 days in jail.
Yes, sir.
Okay, and although you'll be pleading no contest in the domestic violence case, do you understand that if I find the necessary facts to make out a domestic violence in the police report or some other document furnished to me by the attorneys, that has the same effect as a guilty plea?
Yes, sir.
Has Mr. Warden gone over the case in the law with you, and has he answered all your questions to your satisfaction?
Yes, sir.
I need to go over your trial rights with you and make sure you understand all those before I'm able to accept a plea, so please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. Do you understand all those rights?
Yes, sir.
You also have the right to have the witnesses against you appear at trial, to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand those rights?
Yes, sir.
In addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand that?
Yes, sir.
And finally, by pleading guilty, you give up the right to appeal that you'd have if you went to trial. Any appeal would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear your case. Do you understand that?
Yes, sir, I do.
So knowing all of those trial rights that you have, is it your decision to waive them all in order to enter a plea to the reduced charge?
Yes, sir, it is.
All right, I'm going to go first to file 190891, which is the controlled substance case. And it says here in the complaint that on September 24th, you were in Garfield Township in Grand Traverse County, and that you were in possession of some quantity of cocaine. Is that true?
That's correct. That's correct, yeah.
All right, and let's see, were you contacted by police in some way? Looks like you were taken into custody on some warrants, and then they searched you. Is that what happened?
Correct. Correct.
All right. It says lab report confirmed that it was cocaine. So you were made aware of that fact, and is that accurate, Mr. Atwood or Mr. Warden?
That is accurate, Your Honor.
Okay. And you were familiar with cocaine from past experience, and you didn't have any doubt that it was cocaine. Is that correct, Mr. Kowalski?
Yes, sir.
Okay. So then to the reduced charge of use of cocaine, how do you plead?
Guilty, sir.
All right. I'll accept that plea, find it's voluntary, accurate, and understanding. We'll go on to file 4943 of 2021. And in that case, the complaint, well, okay, I'm going to read the police report if that's acceptable to the attorneys. And I'll specifically read the probable cause arrest form.
I think that's appropriate, Your Honor. Thank you.
Agreed, Your Honor. Thank you.
All right, I have read the probable cause statement. It does make out the facts of a domestic violence. So then to that charge, how do you plead, Mr. Kowalski?
Guilty, sir.
No contest, right?
Yeah, no contest, sir.
All right, so I will accept your no contest plea. I find there's a sufficient factual basis in the report that there was domestic violence committed. And so I will accept that plea as voluntary, accurate, understanding. The next step here, Mr. Kowalski, is I'm going to set this for a pre-sentence investigation and a substance use assessment. Sentencing will be, Mr. Warden, you got your hand up there.
I do, Your Honor. I'd either like to make a bond motion or move the court to proceed with sentencing. He does have 3 significant felonies. They're breaking and entering with intent, but they're all 1992 matters. That is the only thing on his criminal history. The court should be aware that this domestic violence happened on March 10th of 2021, and he's been incarcerated since his arrest following that incident. So he has much more than the 93-day maximum on the domestic violence. The court already noted the use of cocaine stems from a September 2008 incident. So we're 3 years old now on the use of cocaine matter. He certainly acknowledges that he had cocaine, but it was a very small amount.
All right. Well, with regard to the domestic violence case, I guess if he has 93 days in there, there's not much more that I can do on that. However, I do have the obligation of giving the victim a right to appear at a sentencing. And so I don't think I can just, because he's had 93 days in jail on that, sentence him, but I could release him on bond, I guess, in that case. So set a PR with I guess I would set a $200 bond on that case. But I think I have to have him in court, and I'm not going to simply sentence him on the use of cocaine charge. What I thought you said at first, and maybe I'm mistaken, is that he has other fish to fry here. He's got some other serious charges, or what?
No, he does not, Your Honor. The only criminal history I have are 1992 matters. So,
okay, that's what you're talking about then.
Correct, and he's spent more than 100 days in jail at this point. So I would ask for PR bonds in both cases. And I understand if we need to come back for sentencing, I totally understand that. I guess I'm just suggesting that maybe the court doesn't need to go through the process of a PSI or substance abuse assessment, but certainly we would be cooperative if the court didn't want that.
All right. Well, the thing is, when I pull up a report and I see a habitual fourth, and okay, they're from 1992, apparently, those habitual cases that are alleged. It seems to me that whether this happened a couple years ago or not, we don't know what's been going on in the meantime, because apparently police were not able to catch up with the defendant on this case, which gives me some concerns as well. So I don't feel comfortable going ahead with sentencing at this point. If I'm going to sentence on a controlled substance charge, I'm going to get a substance use assessment as well. And so let's see. So we'll get the PSI, the substance use. Ms. Odom, you want to work with Mr. Warden on a sentence date?
Sure. How does July 8th at 9:45 work?
At what time in the morning? I'm sorry.
That's okay. 9:45?
Yep, that works.
Okay. And just so we know, the felony felony case bond is a 50,000 PR, so he's not been accruing time unless he's still, I mean, he was at circuit and then he came back here. So I'm assuming our old bond still applies.
Well, he hasn't been able to make bond, so he's getting credit for the time he's serving.
Not in the felony case, though, on a PR bond. His bond should have been converted to a 10% or a cash bond.
All right, well, we'll take that up at sentencing, but I guess at this point, are there any motions regarding bond?
Yes, Your Honor. Again, I served the maximum on the domestic. I would ask the court convert that into a PR bond. I believe what Ms. Odom is saying. So in that case, the other bond is a personal recognizance bond, and I would ask that the court leave that as it is. He served quite a bit of time, and certainly, again, we will be cooperative with the PSI process, and we'll be back for sentencing.
All right, Mr. Atwood, what is the people's position on bond?
No objection to that, Your Honor. I think it's appropriate given the length of time he sat on that domestic.
You know, my concern is that it took a couple years to catch up with the defendant. Can somebody provide me more information why that was? Not on the domestic, but that was on the use of cocaine charge. Did we lose?
May I speak?
Oh, there we go.
They're looking.
Mr. Warden, what do you think? Do you want your client to fill me in?
Go ahead, Roy.
Okay, go ahead, Mr. Kowalski.
Thank you. When I was originally arrested for it almost 3 years ago, 2.5 years ago, I was released that night, and then apparently it was TNT or something like that wanted to talk to me afterwards. They talked to me a couple of times, said they would get back with me, and I really didn't hear anything back. Nothing came of anything. Didn't really speak with them much about anything. They didn't really contact me. And then I was at the same residence, same phone number. I got nothing in the mail saying any warrants, so I was kind of in limbo of what was going on. I tried making contact to find out what should I do? Should I turn myself in? What's going on? We'll get back to you as soon as possible. I actually had made a call to Grand Traverse County and asked if I should.
Let me stop you there. Were you living in Traverse City all this time then?
Correct, at the same address.
Okay. And
Your Honor,
are you a lifelong resident or? Yeah, go ahead, Mr. Warden.
Your Honor, if I may, it looks like this is back in the days when we were having testing issues. This is a September 24, 2018 arrest date. The test actually came back at 1.9 grams, and that did not come back until December of 2018. So 3 months later, and then Mr. Hamlin did not charge this until April of 2019. So it was, roughly 7 months later. So I suspect that this is one that went into warrant status, and Mr. Kowalski just didn't know that he had a warrant. All
right. Well, what I'm going to do then is I will convert this to a $5,010% or $5,000 personal recognizance bond, and in the controlled substance case, and it's $200 in the domestic violence case, and did you pick the date for sentencing yet, Ms. Holden?
I did, the 8th.
The 8th, okay. So we'll be back here then on July 8th. Prior to that time, once you get out of jail, which should be later today, Mr. Kowalski, I need you to contact our probation office. They will set up an interview with you, and they'll talk to you about a substance use assessment as well, okay?
Yes, sir.
Okay, we're all set for today then, unless there's anything else, Mr. Warden or Mr. Atwood.
No, Your Honor, thank you.
No, Your Honor. Thank you.
All right, thank you. And you can let the correction staff know you're all set for now, Mr. Kowalski, okay?
Thank you.
All right, Ms. Odom, do you need a break at all?
I'm okay if you are.
I see Mr. Seeger is back and
Ready.
Mr. Zarko, are you?
It's Mr.
present?
Bat, Your Honor.
Oh, I'm sorry, Mr. Bayat. All right, I've got a couple other matters before that. Well, let's go ahead to the Bayat matter first.
Your Honor, it's my understanding that he's going to admit the violations, Your Honor, at least as it relates to missing the men's group. The other ones, I think he has somewhat of an explanation, and he disputes as untrue that he wasn't engaged in the men's group. But I think the court only needs one violation, and that's probably the most pertinent one.
Okay, what about fail to provide proof of mental health counseling?
Yes, Your Honor, he would admit that as true. However, it's my understanding that he's waiting for some paperwork because he did an evaluation with mental health. He's just not received any paperwork yet, or at least as I understand
I
it.
received it before. It was right after my first hearing. I got the evaluation, and Jana got it too. I don't know if she gave it to you guys or not. It took a while to get to it, so.
Okay, all right. Well, let's start at the beginning here then. So, Mr. Bayat, you understand that you're charged with a probation violation, and the worst that could happen is that your probation could be revoked. You could lose your deferral, and you could get up to 93 days in jail by admitting to a probation violation.
Yes, Your Honor.
Okay, and you've talked to your attorney about this, obviously, and based on your conversation with him, you want to waive your right to a hearing in this case, and admit at least to the men's group violations and the failure to provide the proof of the mental health counseling. Is that correct?
Yes, Your Honor.
And you haven't been threatened, forced, or coerced in any way or promised about what I would do if you plead guilty to the violations, have you?
Have I been threatened?
Have you been threatened, forced, or coerced in any way to get you to plead guilty to the violations?
No, Your Honor.
Have you been promised what I would do by anyone to get you to plead guilty?
No, Your Honor.
Okay. All right, then, is it true you were placed on probation for domestic violence?
Yes, Your Honor.
On December 10th, 2020, and as a condition of that, you were supposed to attend the men's program?
Yes, Your Honor.
In addition, it says here that you missed men's group programs on March 10th, March 17th, March 24th, April 14th, and May 5th. Is that true?
Yes, Your Honor. Some of those is when I just got back to work. So I was working 60, 70 hours a week. So I was like so exhausted from work that I would either go home or pass out, or I'd go home and it would totally just fly past me that I forgot about it. I've been doing a lot better. I've been keeping up on it. I've been going to the classes now. So
you are since May 5th. Ms.
Yep,
Morton
I've been
is
going.
here.
Yep, I don't
Ms.
remember the last
Morton,
time I did this, so.
has the defendant been attending since at least the last miss on May 5th?
Yes, I saw that he did the rest of the classes in May. I have no record of June yet.
Okay, but he's not supposed to report that yet, or he should have reported that.
I'm still waiting for the Women's Resource Center to provide me that document.
I see. Okay. All right, then to that violation anyhow, you're pleading guilty, is that correct?
Yes, Your Honor.
All right. With regard to mental health counseling, you were supposed to provide proof that you were attending that counseling, and you never provided any proof to Ms. Morton. Is that correct?
That is correct. On that one, I had no insurance when I got probation. I was trying to get Medicaid, and they were giving me problems with my address. They were saying my address doesn't exist. I was talking to Jan about me going back to work, and once I go back to work, my insurance would kick on, and then I'd find a place, because there was only certain places that would take my work insurance, and I got with a I think Benzie County Mental Awareness or mental counseling with Frank Langer. I took his evaluation. I have the paperwork somewhere. I think Jana got the.
Oops. Excuse me, Mr. Bayette, you're on mute for some reason.
Oh, I thought I was unmuted.
There you go. Okay, I heard just about everything up to the last sentence there.
But yeah, so like I met with Frank Langer. I got my evaluation. I haven't heard anything. I just got something in the mail yesterday, but it looks like a bill. So,
okay. Well, as far as providing proof to your probation officer, you are admitting you didn't do that, though, correct?
Yes, Your Honor.
All right. And I'll give you a chance to say anything else you want to before I decide what to do here, and we'll hear from Ms. Morton as well. So to that violation, how do you plead?
Guilty, Your Honor.
All right, I'll accept that plea as well. So, Mr. Seeger, there's an additional violation here for the 512. Says unable to pay for urine screen. Is the defendant admitting to that violation as well?
That one I don't understand.
Okay. Sounds like maybe you need to talk to Mr. Bayette some more about that added violation.
He's not really disputing it, Your Honor. He's just saying that he thought that he had went because when he did have the money available to pay, or at least that's what he had explained to me.
Okay. This is the thing, Mr. Bayette, whether you've got the money to pay or not.
It wasn't that I had the money.
But, yeah.
It was, I had the money. I went to the Holiday gas station, which is over by the New Direction testing facility. I wouldn't have gone to Holiday gas station if I couldn't pay for a drug test. So for me going to the Holiday gas station, it was confusing. If I didn't have money, I wouldn't have went there. So I don't know if their computer screwed up. I usually have the receipts laying around, but I can't seem to find a lot of them. But I'm pretty sure I would have paid for it if I went to the gas station and spent over $15 there. So.
All right. So you're disputing that you showed up at New Directions, you were unable to pay for the test, and so they didn't give you a test.
Well, no, they gave me a test. It's what if I can't pay for it that morning, I come back after work because I had to borrow money from my boss. But that wasn't the case that morning because I went to the gas station and spent money. If I spent money at a gas station, I obviously had money to pay for it because I wouldn't have spent it.
You think you did pay for it?
I'm pretty sure I paid for it. I don't know if their computers like screwed up when they put it in or what, or if I paid cash that day. But I remember that day very clearly.
Okay, Ms. Morton, do you have any additional information about that or just the report of a no pay at New Direction?
I have just the report of a no pay, and then I just searched Redwood Labs for test results that we get, and I have one for April 28th. in May 24th, so I don't have a test result for May 12th.
It's so weird. Because I wouldn't be down on that part of town if I didn't go there.
All right, then. Okay, so, well, let's skip that violation for right now. I'm not sure that that's going to make any difference in my opinion here about the case. So go ahead, Mr. Seeger. Anything you want to say on behalf of Mr. Bayat?
Your Honor, on behalf of Mr. Bayat, it appears as though he was at least making a good faith effort to attend some of his counseling, for which when I was talking to him, he had expressed that he had learned certain things from there. He had expressed that in a group setting, he somewhat struggles based on maybe some of his mental health problems, but he does better in a solo type situation, which I think he'll be able to address with his mental health professional. I think that it's maybe somewhat distinguishable as much as if somebody has a mental health problem, they're probably struggling with a lot of other things other than just general edicts that are set forth for people who are not necessarily similarly situated. So I'm happy to see that he's engaging in the mental health component, which is probably a large part of the reason why this may have happened to begin with. But like just looking at the progress notes from the men's group, he's not getting 10s. They're not saying that he's superior, but they're not saying that he's entirely deficient either. They're just saying that he's quiet. There was another note saying that he improved and he had participated in another class. So I disagree with Ms. Morton's characterization that he's not necessarily benefiting or participating in the classes, because he is. And I think that each person's participation level is probably somewhat different, just depending on how they are as a person or how they accept the information. But either which way, I would not necessarily want to discharge him from probation if given the opportunity to continue on probation. It's not required by statute that we revoke his probation or that we revoke his deferred status. I think that if he's getting the mental health help that he needs, that's helpful. I'm glad that he's gainfully employed, because that probably takes his mind off things, and that probably also helps him. I guess I'm just looking forward in the interest of justice to allow him or afford him to have an opportunity to continue working on some of the things that he probably clearly needs. But I guess I'm primarily happy that he's working full time, and also that he's engaging in mental health, which is probably one of the key things that he needs to work on. Not to say that he can't benefit from the men's group, but simply for the reason that the mental health is probably the larger concern that I would hope that he would work on. So to that end, Your Honor, I would just ask the court to consider continuing him on probation and not revoke his deferral. If anything, Your Honor, if the court just determines that there has to be a sanction of some sort, I guess I would ask the court to revoke his deferral, but allow him to continue on probation, because if he goes to jail, he's presumably going to lose his job, which breeds instability, which probably means that everything's going to totally fall apart, which I don't want to happen for Mr. Bayat. It does appear as though he's now going to his men's group regularly, so that's also a plus. I think that maybe if we give him one more opportunity, it's impressed upon him the importance of communicating with Ms. Morton, definitely impressing upon him the importance of continuing on with the men's program, and definitely working with his mental health provider. So I would just ask the court to consider not revoking his deferral, but if it did determine that that would be the appropriate course of action, to not impose any additional jail and to allow him to remain on probation.
All right. Thank you, Mr. Seeger. And Ms. Wilson, is there anything you'd like to say?
Yes, Your Honor. As far as the men's group goes, it appears to me from an email that was provided to his probation officer that he doesn't really seem to be taking it very seriously, and he doesn't seem to be willing to participate in it. And Since he's had several violations, I think we would ask for some jail time. I believe the probation officer recommended 30 days and to revoke probation.
All right, thank you. Is John Natzel present?
Yes, sir.
Oh, okay. I'm going to put you in a breakout room with your attorney, Mr. Johnson.
Okay, thank you, Your Honor.
Yeah. Okay, I want to give Ms. Morton a chance to respond to some of the, well, let's hear from Mr. Bayette first. You've told me some of the reasons why you haven't been compliant with probation. Is there anything else you want me to know?
I mean, not really as of right now. I mean, the last few years I've had like a really bumpy road, so I'm just trying to get back to a stable life, and it's still really stressful for everything going on.
All right, so I've heard that you're going to counseling, is that right?
It is.
Who
I
do you
see
counsel
I
with?
see my psychologist too, Pine Rest, Dr. Wilkinson.
Okay,
He's,
how often are you seeing Dr. Wilkinson?
It's usually like once a month. That's the way it's always been. It's either for medication or I sit down and talk to him about how everything's been going, all
right, and where are you working at?
Give him a break safety out in Kingsley.
Give him a break, what?
Safety.
Oh, what do you do there?
We do traffic control. So like all the drums and signs, everything that are like Chum's Corners, we lay all those stuff out.
I see. Okay. And you're working full time right now?
It's full time, but seasonal.
Okay. All right. Well, Ms. Morton, is there anything you'd like to add?
Yes, Your Honor. I just have, the concerns with the men's program. I think his email says it all, how he feels about the program. So I don't know how he can go forward with that and be successful. And also the lack of communication. I was completely unaware that he had missed 5 of those meetings. So his communication with me regarding that is as simple as trying to get excuse from them. I'm not saying he would have been, but there absolutely was no communication regarding that. And I believe mental health counseling is essential for him. The thing is, he was sentenced in December. I kept asking him every month, have you gotten it? Have you gotten it? He had mentioned insurance. He did get the evaluation done. I received a copy of it June 3rd. And it said to continue his appointments with Dr. Wilkinson. So I have asked him to provide me proof of those appointments. And I have not, since he's been on probation, received any proof that he has had any appointments with Dr. Wilkinson.
You just emailed me that like a couple weeks ago. I have an app I'm trying to get onto that has all my appointments. He doesn't send me paperwork of dates. It's on an app.
Dakota, just a second. I was addressing the judge. And so I've asked him since December to provide me proof of mental health. And if he was going to Dr. Wilkinson at that point, he never told me and he never provided me proof. So he is correct. On June 4th, I did ask him for that. And as of June 4th, I still have not received it. So I'm not quite sure if he is attending or not. If he is, that's it. That's great. But it's the communication part that's not working. Thank you.
Okay, well, this is sentencing on at least 2 probation violations where the defendant failed to attend the men's program on 5 separate dates. Apparently, he is now attending, at least for May. We don't know for June yet, although the defendant has stated that he is. there was also a violation alleged for lack of cooperation with the men's program, and that was owing to a detailed statement by the defendant in an email about how he's not getting anything out of the program. He thinks it's a waste of time and money. He doesn't want to listen to other people's problems, and doesn't think that this is his major issue anyway. So the defendant explained his failure to attend those earlier meetings of the men's group, saying that he was too busy working. And so this is the thing, Mr. Bayette, you're here for a domestic violence charge, and you got 2 prior assault and batteries on your record and numerous other offenses, and you don't get to make the decisions anymore, okay? Except if you just don't want to participate, that's a decision, and it won't be the 90 days that Ms. Morton's suggesting. It'll be the whole load, okay? And you probably would lose your job and all that other stuff. You seem to want to just do this however you think it should be done, but Ms. Morton is not here to chase you down for reports. That's your job when you're on probation.
Can I say something?
No,
Okay.
you're done. You had your chance. I have to make a decision. And you should be apologizing to Ms. Morton, frankly. I'm going to go out on a limb for you today, however. The fact that you have started the men's program, and it's not just going and sitting in the back and sleeping through it, because that's not cooperation. And the men's program folks will let me know if you're not cooperating in the program. But I probably told you at sentencing, you can go there and sit in the back and waste your time. That's what you're doing. You're wasting your time. That's good information at those meetings. And if you're going to be there anyway, you should try to get the most out of it. Okay? You obviously have some anger management problems because you're sitting here in court facing 93 days in jail on what, your 6th criminal offense? If that doesn't make you think, well, okay, so that's besides the point. You've been involved with the justice system at least half a dozen times, okay? And these programs are intended to keep you from coming back here. I don't want to see you anymore. Ms. Morton doesn't want to see you anymore. We want you to be successful. And it sounds like there's a lot of positive stuff going here. You've re-engaged with Dr. Wilkinson, apparently. You're going to the mental health counseling that is helpful to you. And you're working full-time. And even working way over time. So anyhow, what I'm going to do, instead of taking away the deferral and the probation, is I'm going to continue the probation, but you are going to go to jail for 3 days to make the point that that's where you're going to end up. And again, it's not going to be the 30 days that Ms. Morton's recommending. This is your 3rd assaultive offense. It's going to be the whole 93 days with credit for time served. But you need to engage in the program. You need to get the documents to Ms. Morton and cooperate with her. When do you have, did you get the weekend off?
What's that?
Do you have the weekend off?
It depends on how busy we are. Most
Okay.
weekends we have off, but sometimes we do have to work the weekends.
All right, well, then you're gonna have to explain to them if they want you to be there this weekend, why you can't be there. So I will give you until Friday at 6 p.m. to turn yourself in. You'll be out sometime on Sunday morning. And again, the purpose of this is to hopefully reset your thinking on this whole thing. And again, there's a lot of positive stuff going on here. If you're engaging with Dr. Wilkinson, if you begin to not just go to those classes, but cooperate and get what you can out of it. So that's it for today then. And don't forget to turn yourself in by 6 p.m. on Friday. Thank you. We're all set.
Thank you, Aaron.
Yep. Thank you, Mr. Sager. Okay. Let's go to Karina Chenard. That's file 214899. And this is the date set for a plea. Ms. Claxton is here on behalf of Ms. Chenard. And is that what your client still wishes to do, Ms. Claxton?
That's correct, Your Honor.
Okay, and is there a plea offer?
There is, Your Honor. Ms. Chenard is charged with 1 count of domestic violence. It is our understanding of the plea offer that Ms. Chenard may plead guilty to domestic violence with a deferred sentence. That deferred sentence being the whole 1-year probation term. And additionally, the prosecutor's office would recommend mental health treatment instead of the standard terms of probation of the domestic violence.
So mental health treatment as opposed to, say, the men's program?
Correct.
Okay, so Ms. Wilson is here from the prosecutor's office. Are you able to confirm that's the plea offer and the recommendations?
It is, Your Honor.
Okay, thank you. And Ms. Chenard, you're muted right now, but you can unmute yourself. And is that your understanding of the plea agreement? You're going to plead guilty, but with the understanding it would be a deferred sentence for a 1-year probation, and that you would be required to engage in some mental health services as a condition of any probation.
Yes, Your Honor, and I've already begun the mental health services for a total of 6 months with Northern Lakes.
Okay, good to hear. Is that going well?
Yes, it is going well. They have my bipolar under control, and I'm actually living with my mother who was the victim. So we have reconciled, and things are looking on the up.
Okay, so at some point the court must have lifted the no contact then. Is that right, Ms. Claxton?
That's correct, Your Honor. We did it by stipulation. Ms. Chenard ended up doing some residential mental health treatment, and then her mother, who's the alleged victim in this case, thought that it would be best that she and her son move in with her and Ms. Chenard's father after that. So the prosecutor's office did stipulate to that, and we did enter a stipulation in order.
Okay. Well, I'm glad to hear all that. So let's go to the plea then. So Ms. Chenard, have you been promised anything else other than the deferred sentence in order to get you to plead guilty, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, I have not.
Has anyone promised you anything about what I would do in order to get you to plead guilty? Now, with that, let me say that I typically would go along with the deferred sentence. If for some reason I weren't going to, I'd allow you to withdraw your plea. But other than that, has anyone promised you anything about what I would do in this case?
No, they have not.
All right. Do you understand that by pleading guilty, if you don't comply with the conditions of the deferred sentence, you could be sentenced up to 93 days in jail and the deferral could go away?
I do, and I am excited to have some structure. So it will be good. Rules and structure.
Okay, great. That sounds perfect. So has Ms. Claxton has she answered all your questions to your satisfaction?
Yes.
All right, I do need to go over your trial rights with you and make sure you understand them before I'm able to accept a plea, so please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. Do you understand those rights?
I do.
You also have the right to have the witnesses against you appear at trial to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand those rights?
I do.
In addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand that right?
Yes, sir.
And finally, by pleading guilty, you give up the right to appeal you'd have if you went to trial, and any appeal of your conviction or sentence would be by leave, not by right, meaning it would be up to the appeals court whether to even hear your case. Do you understand that right?
Yes, sir.
All right, so knowing all of those rights, is it your desire to waive them all in order to plead guilty with the understanding the sentence would be deferred?
Yes, Your Honor.
All right, then. Before we go any further, I just realized we have Mr. Mathis here. Mr. Mathis, you want to turn on your audio?
I'm here.
Okay, well, I wish I would have thought of this earlier, but your attorney is in the emergency room this morning and cannot be here. And so for that reason, I am going to adjourn your preliminary examination. The prosecutor was given word of that, so I assume there's not any objection to that, Mr. Atwood?
There is not, Your Honor.
Okay, so that just, as I understand it, the attorney just went in this morning, and so there wasn't probably any time for her to try to get word for you, and I don't know what her condition is either, so.
She stated she hasn't been able to get in touch with him,
So
so maybe we need a number.
She did state that she's had difficulty getting a hold of you and wasn't even sure that you'd be here this morning. And I want to make sure that we have a good address and phone number for you, Mr. Mathis.
My address is 3875 Eagle Pass. That's Acme.
Okay, that's what we've got. And can we get a phone number? Yep.
Phone number is 231-493-1269.
Okay. This is the thing. We'll pass that information on to Ms. Mistely, but if you could reach out to her maybe in a couple days here, we'll reset the prelim probably a week or 10 days from now. But if you could reach out to her and make sure you're not just missing her calls because the volume's not turned up on your phone or something like that. But for some reason, she hasn't been able to reach you, okay?
Hey, do you have a phone number for her?
Yes, we do. Ms. Odom, you want to provide that to him?
Sure, I've got to Google it. Hang on.
And today may not be the best time again since she's
Yes,
in the hospital.
Yes, Your Honor.
Could you have a, are you ready?
Yeah, I'm ready.
231 944
Okay.
3996.
I got it.
Can you repeat that one more time?
231-944-3996.
Yep, I got it.
Okay, great. All right. Well, we're all set then for today, Mr. Mathis, and you'll get notice at that address you just gave us of the next date for a hearing. But make sure you get a hold of Ms. Mistley, okay?
Thank you, Your Honor.
All right. Thank you. All right. Let's go back to the Chouinard case. Sorry for the interruption there, but I didn't want to keep Mr. Mathis waiting any longer. Now I need to establish the facts of the case. Let's see. So is it true that on February 26th, you were at a location 782 Watch Hill Lane, number 1, and you were with your mother, apparently, Ann Chouinard?
Yes, she showed up on
okay.
the scene.
Oh, okay. So that's your address, Watch Hill Lane?
That was my apartment, but I now had some financial issues to move back in with my parents.
Okay. And obviously, Ms. Chouinard, your mother, she was a resident or former resident of your household?
Not of the apartment.
But she had, obviously, at one time, you grew up with her, so she had to be a resident of your home. Okay. And did you make an assault on your mother?
I did. I twisted my mom's broken nose.
Okay. And obviously, that would be painful for anyone if they got a broken nose. And you weren't acting in self-defense. It was meant to be injurious to her.
It was facetious and I was disrespectful.
All right. Okay, then to the charge of domestic violence with the understanding the sentence would be deferred. How do you plead?
Guilty.
All right, I will accept your plea. I find it's voluntary, accurate, and understanding. Ms. Odom, you want to work with Ms. Claxton on a date for sentencing?
Sure. How about July 8 at 8:30? It's a Thursday.
That Thursday is not good for me. Can we do it the Thursday before or after?
After would be better because we'll probably get a PSI if that works. And we could do it at 9 on the 15th if that works.
Perfect. Thank you so much.
Okay, so we're going to be back on that date, Ms. Chouinard. Prior to that time, I do need you to contact our probation office. I'll give you a number to call. Please call between 1 and 4 p.m. today, and they'll interview you about what happened, okay? So here's the number. It's 231-922-6899.
Okay, thank you, Your Honor.
All right. Thank you. I'm glad to hear. It sounds like things are going very well for you, and glad to hear all that. So feel free to sign off at this time, and thank you, Ms. Claxton. We'll go on to your next case. That is People versus Brittany Humphrey. And Ms. Humphrey is here for sentencing on the conviction of domestic violence with the understanding it would be a deferred sentence. Ms. Wilson is here for the People. And let's see, Ms. Claxton, have you had an opportunity to go to the pre-sentence report with your client, and is it accurate and complete?
Your Honor, we did have a chance to go over the pre-sentence report and substance abuse assessment. Ms. Humphrey noted one factual error that certainly isn't going to affect the sentence, but on her substance abuse assessment under family history, it notes that she's the oldest child. She reported to me that she's the second oldest child.
Okay. All right, we'll make that change then. And anything else with the report?
That was it, Your Honor. Thank you.
All right. Ms. Wilson, any concerns with the report?
No, Your Honor, thank you.
All right. So what would you like to say on behalf of Ms. Humphrey? Ms. Claxton?
Thank you, Your Honor. Your Honor, as noted in the pre-sentence report, Ms. Humphrey has no previous criminal history. I think this speaks very well of her character. In this incident, she unfortunately had an argument with her mother. Alcohol was involved, but as noted in the substance abuse assessment, there aren't any concerns about her substance use or need for treatment. Ms. Humphrey has been very proactive in her case. She has already started the AWARE program. We think that she's a great candidate for the deferred sentence, and we'd ask that the court follow the deferred sentence.
All right. Thank you, Ms. Claxton. Ms. Humphrey, is there anything you'd like to add before I sentence you?
Not that I can think.
Oh, okay.
I've been to the AWARE program 4 times already.
Okay. All right. And let's see. I did have a question for you. It says you went through 11th grade, and have you made any efforts to try to get your GED or a diploma?
Not yet.
Okay. Well, you know, that's really important in today's economy, and you might want to think about that. So let's see, Ms. Wilson, anything you want to say?
No, Your Honor, thank you.
Okay, so this is sentencing on defendant's conviction of domestic violence, and the facts are that the defendant and her mother were arguing. The defendant shoved her mother to get her out of her way. They started physically fighting, and according to the victim, Ms. Chouinard, she said she got out of bed when the defendant pulled the blankets off her. The defendant grabbed her by the neck, punched her in the face, pulled her hair, and pushed her up against the wall before she could get away to call the police. To the defendant's credit, she has no prior criminal history. She's a stay-at-home mom with 4 kids, including a 1.5-year-old. And she has already engaged in the AWARE program. She's done 4 classes with them. And so I think the recommendation for the deferred sentence makes perfect sense in this case. So if you comply with all the conditions of probation, there won't be any conviction at the end of this. You'll keep your clean record, and that would be great. So the probationary term is 1 year. There will be no early release from probation. That's been agreed upon with the prosecutor. The fine is $100. Yeah, go ahead, Ms. Claxton.
I apologize for interrupting. This was one where Miss Humphrey had been on bond for about 5 months and was doing very well on bond. So the prosecutor's office did agree at her final conference that should she complete all of the terms and conditions of her probation, including the all 36 weeks of the AWARE program, that she could petition the court for early release if they found it necessary and appropriate.
Okay. Is that correct, Ms. Wilson?
It is, Your Honor. Thank you.
All right. Well, thanks for pointing that out to me, Ms. Claxton. And so the defendant may ask for early release at the 6-month mark then, if all the conditions of probation have been met. Those conditions are going to include, first of all, that the defendant I'm not sure. Did I go through the fines and costs already?
You started, you were at 100.
Okay, fine is 100, cost 400. Crime Victims Fund 75, judicial system fee is $50. I'm going to waive the court-appointed attorney fee since the defendant is a stay-at-home mom and has 4 young kids. Let's see. During the term of probation, defendant is not to consume or possess alcohol, marijuana, illegal drugs, minor mood-altering substances, including marijuana, and is to provide a copy of any prescription she does have for medications. She's not to enter bars or casinos, except for work purposes, should that be an issue. She is not to possess firearms or weapons or reside where those are present, not to behave in a violent, threatening, intimidating, or harassing manner, and be respectful of all court employees and care providers. She is to attend all 36 consecutive weekly sessions of the AWARE program with no unexcused absences. Take and pass have we had any violations of bond that you're aware of? Yeah, we have. Okay. So I'm going to continue the 4 times a month testing for alcohol. The probation department may adjust those if you're doing well. There's discretionary testing for alcohol or drugs. And jail is credit for time served, which is the 1 day that you were arrested. Let's see, there'll be no contact with Joy Statmiller. You're not to go within 500 yards of a residence or employment. And other than that, you need to notify the probation office if you have any contact with law enforcement.
Okay.
You need to contact the number on the pre-sentence report after 1 o'clock today and before they close at 4. So make sure you do that. They'll go over the terms of probation in more detail with you and answer any questions you might have. Okay?
Okay.
All right. We're all set for today then, Ms. Schwinard. Good luck with your probation, and I hope I'm able to sign a successful discharge from probation 6 months from now. So
I think you said Schwinard.
yeah. Okay. Thank you.
Thank
Or
you.
Humphrey, I should have
Yes,
said.
you meant Humphrey.
Yeah. Okay. Now let's go to our preliminary examination, file 215299FY, People versus John Natzel. And Mr. Natzel, are you able to hear me okay?
Yes, sir.
Okay, Mr. Johnson is here on behalf of the defendant, Mr. Atwood for the prosecutor's office, and Mr. Johnson, this is set for preliminary examination today. What does your client wish to do?
Thank you, Your Honor. Your Honor, I had some discussions with Mr. Hamlin on this matter, and as a result of that, some efforts were made that I don't want to go into on our part. Work on global resolution to everything. I did get a response on that from Mr. Hamlin yesterday. However, I wasn't able to get a Zoom meeting with my client, and that's why we used a breakout here this morning. We would like to consider what the prosecution has offered, and as such, we would be asking for an adjournment here this morning.
All right. Are the other cases that Mr. Natzel's dealing with, are they in front of me or Judge Stepka?
We're spread out. The other felony cases with Judge Stepka, the prelim is set for July 7th on that.
Oh, okay. All right. Well, if there's going to be a plea, it would probably, or a waiver up to circuit court, it probably makes sense to have both cases in front of the same judge. So if you could just let the court know in advance what's going to happen, if you're able to do that, that would help. And probably before the 7th with the other case hearing. Let's see, Mr. Atwood, are the people agreeable to adjourning the case?
Yes, we are, Your Honor.
Okay, and is this a first adjournment in this case, Mr. Johnson?
I believe it is in this case, yes, Your Honor.
Okay, so Mr. Nassel, you by statute have a right to have your hearing within 21 days of an arraignment or 14 days of a probable cause conference. And obviously that's not going to happen if you're going to take some time to consider the plea offers that have been made. So, but anyhow, do you agree to waive your right to have that hearing for good cause in order to consider that offer?
Yes.
Okay. All right. So the hearing is adjourned for today. And Ms. Odom?
Yeah. I'm going to reset the prelim to 7-8, if that works for you at 11.
We will make that work.
Yeah, and if there's a global resolution, just contact us and we'll try to get that all set before one judge to make it easier.
Thank you.
Thank you.
Okay,
Thank
we're
you.
all set for today. Thank you, Mr. Johnson and Mr. Atwood. And we'll see you back here on the 8th, Mr. Nassel. So you can let the corrections staff know you're all set.
All right. Thank you, Your Honor.
Thank you, Your Honor.
Thank you.